For the appellant, have you already reserved your time?
Yes, Your Honor. May I reserve 5 minutes of my time?
Thank you.
Thank you, Your Honor.
You may proceed.
First, Your Honor, I want to thank opposing counsel for his collegiality and professionalism. He is a gentleman in the practice of law, and it's been a pleasure to practice against him.
Are you talking about Mr. Morton?
Oh, is that who it was? I take it back.
Just kidding.
And he's also effective, and that's how we wrongly got here. So let's see if we can correct the error. In this case, there was only one person offered as an expert at trial, and that was plaintiff's expert, Dr. Alpert. Dr. Alpert verified that the pursuit procedures and guidelines contained in the Knox County Sheriff's Department manual are the standard of care or the duty owed in this particular police pursuit. And so while that manual may have been made in the abstract for application all the time, Dr. Alpert did verify that it was the proper standard of care or duty owed in this specific case. The trial court has already ruled that the Knox County Sheriff's Department violated their own procedures and guidelines in conducting this pursuit. So if the guidelines are the duty, the trial court has already ruled that duty has been breached. As I see it, the issue that is now before this court is that standard of care contained in the manual the duty or not? If it is, as I said, the trial court has already ruled that duty was breached. The trial court declined to follow the manual's guidelines in coming to its ruling. In Haynes v. Hamilton County, a Tennessee Supreme Court case from 1994, I think has the standard to be applied by this court in determining if that was appropriate by the trial court or not. And in Haynes, there were several factors that are to be considered in determining whether a police officer was negligent in a pursuit or not. I would note that each of the factors in Haynes have already really been considered by the experts who are the employees over time of the Knox County Sheriff's Department in deciding what they wanted their procedures and guidelines to be for their deputies to follow in pursuits. And so these issues we see raised in Haynes, the speed and area of pursuit being one factor to consider, weather and road conditions being another factor, presence or absence of other traffic as another factor. These are factors that would have been considered by the Knox County Sheriff's Department as it drafted its guidelines. One of the factors in Haynes is the applicable police regulations. Well, these other factors will have folded into them the applicable police regulations. So in my mind, the applicable police regulations are a factor that bears more weight than the other factors, because the applicable police regulations took the other factors into consideration when they were drafted, and they were obviously drafted by people who had the opportunity to really contemplate what they wanted the standard to be for police pursuit, and those people were highly qualified at the Sheriff's Department to make that decision, what they wanted the pursuit procedures to be. And those pursuit procedures were violated. They were not followed in this case. And Dr. Alpert testified that those pursuit procedures were the appropriate standard in this specific case. Now, as to the other Haynes factors, the speed and the area of pursuit, it was an excessive rate of speed. The weather and road conditions, in my mind, are a non-factor in this case. They're not a factor that would bear on the decision. The presence and absence of other traffic. Yeah, it was a light traffic flow on the road that day. The alternative method for apprehension, though, is the next element I would really draw the court's attention to, because the deputy had obtained the license plate of the fleeing vehicle. He can stop at this point. He doesn't know immediately. He called dispatch to ask for the information associated with that tag number, and dispatch said the computer system was down, such as life these days, right? Computer system goes down, we're dead in the water. He can pull over and follow the procedures. Turn off the light, turn off the siren, pull over, wait for the information. Here's who owns that car. Here's where you can go and start your investigation from that end. You do not have to continue this high-speed chase, sustained high-speed pursuit, not my verbiage, not my terminology. That is the terminology the Knox County Sheriff's Department uses in their own manual and guidelines. And the trial court determined that this pursuit met the guidelines in the manual of a sustained high-speed pursuit down a dangerous downhill S-curve around a series of cliffs, basically. And he doesn't have to do that. He can pull over, he can turn off the lights and siren, he can wait for the information to come back, he can go to the owner of the vehicle and ask, do you know where your car is? Well, yeah, I loaned it to so-and-so.
But he hadn't gotten to that point, though, had he? As far as, like the system was down or something. He didn't have that verification, though, did he?
He did not, no.
Yeah.
He doesn't, he can pull over, turn off the lights and siren, and wait for the verification to come through. He's got that tag number. He's just waiting for the system back at dispatch to come back up and tell the dispatcher, the system to tell the dispatcher what that information is for the dispatcher to then tell that to the deputy. And the deputy.
I think the only issue with that, though, is you're assuming that his only goal is to identify who the driver is and ultimately go find him and arrest him. But what is his goal also not to stop someone who's try to stop someone who's engaging in very dangerous behavior? So if he did what you did and just quit, and then the wreck happened, we still have a lawsuit, maybe saying, well, he didn't do everything he should have done to stop this car from careening around on Clinton Highway.
The rabbit doesn't run if it's not chased. And if he will follow his own procedures and guidelines he was trained on and pull over and turn off the lights and siren, the fleeing vehicle is going to slow down and stop this aggressive high-speed maneuver down the roadway. Does the wreck still happen? I don't know. That's an alternative that didn't come to fruition. But the idea is if the officer will stop pursuing, stop chasing, then the pursued will slow down and stop the behavior. And I think the question slides into the final factor, the danger posed to the public by the suspect being pursued.
Excuse me for interrupting, counsel. You've made reference to turning off the siren and the blue lights. As I understand, the siren was disengaged, but blue lights continued. Is that correct? Is there evidence that there were blue lights continuing?
I believe the deputy himself testified he never turned the blue lights off, and our witnesses, the two Mr. Williamses, testified the blue lights were never turned off.
Was there testimony that the blue lights continued to be engaged to warn other drivers of a dangerous situation?
I think that's what the deputy testified to, but the deputy also testified he continued to follow the fleeing vehicle and never had it out of sight.
So how does that testimony or evidence bear upon your client's position?
The fact that he continued to be within sight of the fleeing vehicle is part of the problem. He should have followed his own procedures and pulled off, letting them continue down the road around the curves out of sight. And the siren being on, there's mixed testimony on that. It's unclear if the siren was on or not. Because I want to say one of the Williamses said the siren was still on, as I recall. But the turning off the lights and sirens and pulling over while the light's on, we may think as lay people that's warning other traffic. Well, the Knox County Sheriff's Department said in their own procedures, you're to turn them off. Because as long as they're back there flickering, they're encouraging the fleeing vehicle to keep on the gas and keep engaging the behavior of the aggressive speed down the hill through the S-curves. That's why you should turn those lights off. So while maybe they could warn traffic, that's not what the procedure said you should be doing. You should be turning them off to stop the fleeing vehicle from so aggressively fleeing. And we must remember.
I don't know. You're making an assumption there that the rabbit won't stop running unless he stopped being pursued. And in this case, he wasn't actually pursuing at that point. He slowed his vehicle with the blue lights on, but with the sirens off, though, didn't he?
That was the testimony of the Williamses. Both Williamses says the police officer was 2 to 3 seconds behind the fleeing vehicle, and the officer himself said that he never let the vehicle get out of his sight as it went through these S-curves. So while the lights are on, he's keeping the lights in the view of the fleeing vehicle.
Until he had verification as far as the fleeing vehicles, wouldn't he have an obligation to do that?
No, he would have an obligation to balance what the original offense was versus how aggressively he should pursue, and the original offense was running a red light.
Yeah, but with this type of pursuit, there's a possibility that's more involved until he can have some type of verification that this vehicle has not been stolen or anything of that nature involved in commission of a violent felony or something of that nature. Wouldn't he have an obligation to keep that vehicle in sight, even though he may not be actively pursuing, but wouldn't he have an obligation to keep that vehicle in sight until he have that confirmed?
That is not contained in the procedures and regulations of the Knox County Sheriff's Department, and I would say no, he has to make decisions based upon the information he has. Otherwise, we're just Monday morning quarterbacking him with information he didn't have. He needed to wait, gather the information, and then figure out what he needed to do, and should be making decisions in that moment based upon what he knew, which was he had a car that ran a red light.
Yeah. You have your rebuttal time. Yes, sir.
If the court please, I'm hard of hearing, and as a result, one problem is I don't know how loud I'm speaking, so if I yell at you, I'm sorry. And it's not deliberate. And if the court please, he's arguing that the applicable police regulation that the Knox County Sheriff has subsumes or takes over all the other factors and makes it a part of the regulations, and that makes the regulation itself most important, or the only thing that's important. And I think clearly the case, the Haynes versus Hamilton County case makes it just one factor, is what the police regulation is. What we have here is we have a court that determined that the evidence did not support the allegations that the pursuit was negligence. And there's no other, based on this record, there's no, to preponderate against that finding, there has to be another finding of fact with greater convincing effect. And there is none. They didn't prove causation. We've got any number of other reasons that this wreck could have happened. First, and most important, I expect, is this driver was the entire time driving dangerously. He went through a red light after 1001, 1002 at 50 to 60 miles an hour that's got 2,500 cars a day going through. The whole time he's driving like a maniac. And his driving itself was the cause of the wreck. Additionally, he's driving in a car that has bald tires on it. He's fishtailing at 30 and 40 miles an hour. And third, the sustained high-speed pursuit lasted a mile. The Clinton Highway goes up the hill. It's generally uphill. It's got one downhill and back up. And then at the top of the hill, it goes down where it gets very dangerous. And it's a little straightaway. Then it gets into those curves. At the top of the hill, he turns his siren off, pulls over in the right lane and slows down. And the fleeing vehicle, he's going 90, 95 miles an hour. He keeps going. And so there's a question, I don't think there's any other scenario that would cause this wreck, is one thing, if the court please. Also, all the factors in the Haynes versus Hamilton case, if you look at all of them, the manner of the pursuit, he's pursuing at high speed for about a mile, maybe a mile and a half, and he's on his alternative pursuit. He's on the radio, and it's in the record. The entire conversation during their pursuit is in the record, and the court listened to it. He's waiting for the 2829 report back. If the car's stolen, he's got to continue. If there's a felony been committed, if there's a kidnap victim, he's going to continue. If he gets the address and it's not a stolen car, he's going to the address. That's his alternative to his pursuit. And when they get to the top of the hill, he backs off, and he's a very experienced sheriff's deputy. When he gets to the top, he turns his siren off, and in his experience, when his siren's off, the fleeing person, they quit looking in the back. They're watching up front. He did say he kept his lights on to keep traffic aware if there was a situation behind him. He did do that, but his alternative was to go to if he got the report from the dispatch, he'd go there. He kept asking for it, and he would have gone there. That was his alternative. Other factors, the weather and road. Well, if it's raining and slippery, he's not going to go 80 miles an hour up that hill to start with. And I've told you about the alternative methods of apprehension. He's waiting for that report back. He never got, but there's some case law in my brief. He has a duty to apprehend these people, this person. But he has to do it in a reasonable manner and not be negligent. And I don't think the facts bear out that he breached his obligation to be reasonable in his pursuit. And I referenced Crumley versus City of Smyrna, the case where to hold a government entity liable for the actions of a police officer in commencing a high speed or continuing a pursuit, it must be shown the officer's decision was unreasonable. You can hear the communications from the officer. There's exhibits that show where the pursuit happened, how it happened, but as far as the evidence doesn't seem to indicate that there's any other possible cause of it, that this accident was caused by this pursuit. No bald tires. The guy's driving crazy to start with. It turns out he's high on methamphetamine, and that made a difference to the medical examiner. Her testimony made a difference to the judge. He gave the highest credibility to her testimony. And she attributed his poor driving to his meth, so his inordinate amount of methamphetamine in his system. So if the court pleases, that goes to causation. There's no other proof that anything else other than the tires, his speed, these curves caused this wreck. It wasn't the pursuit. That's what the court saw, and I think that the evidence doesn't preponderate against it because of these other options, if the court please. They also presented a fact witness that testified that the pursuing vehicle stayed the whole time, pursued the whole time. Well, she was not reliable, and the court discounted her testimony, didn't buy it. They tried to prove that the pursuit continued the whole time, and she was obviously not a credible witness. As far as the siren being on, Mr. Eddie Williams at the transmission shop, he said he wasn't sure if the siren was on. He wasn't sure. He thought it was, but he wasn't sure. He didn't say the siren was on. He thought it was, but he wasn't sure. And the police chief or the deputy said he turned off the siren, and he was waiting on the 2829. So the question is did the officer do what was reasonable? and he's got a car that's blowing through an intersection on Clinton Highway where school buses and pass by, and it's blowing through there at 50 to 60 miles an hour. He pulls them over, then they start fleeing, going through parking lots, and then they have a high sustained pursuit. And he testified something was going on here. And he had a duty to protect the public, and he was doing everything he can to do that. And once he was going to get the report, the 2829 back, if it wasn't stolen and they had an address, he was going there. But he had a duty to protect the public, and he was doing what he thought he had to do, if the court please. Thank you.
Thank you, sir. Your rebuttal?
The rabbit doesn't run if it's not being chased analogy is not mine. That was the analogy that Dr. Alpert used. And Dr. Alpert explained how studies have been done that show that if you can get the lights out of the view of the fleeing vehicle and the person doing the fleeing doesn't hear the sirens anymore, they will slow down and start driving in a more reasonable manner. And so that's why Dr. Alpert testified that the guidelines established by Knox County Sheriff's Department were good guidelines, because that's what they required the deputy to do.
I wonder if that slowing down of the person being chased still applies if the driver is high as a kite on meth.
Dr. Alpert seemed to testify so, yes. That whether someone usually doesn't want to be pulled over because they're afraid of they're going to get caught or punished for whatever else they're doing in the vehicle. And so they are often in an impaired state when fleeing from the police.
Assuming, for the sake of assuming, that the statute was violated, not complied with, what about the other factors, causation, bald ties, intoxication, speed, driving excessive speed in a crowded, somewhat of a crowded, dangerous area? Are those factors that are to be considered or not?
Those would be factors to be considered in a negligence cause of action against the driver of the fleeing vehicle. The speed and area in Haynes lays out the factors for pursuing a negligence cause of action against the police department, and Haynes is the case that established in '94 that the negligence of the fleeing driver does not a superseding intervening act that cuts off that chain of causation as far as the police department, that you can pursue that negligence action against the police department. So a lot of what we're talking about here also shows the extreme negligence of the fleeing driver, which we don't have a cause of action here against the driver, the fleeing driver. We just have a cause of action against the police department. And Haynes allows that, starting in '94 for the first time, that you can pursue that cause of action against the police department for how they conduct the chase. In my mind, the police officer, that the plaintiff did not engage in what I would call an unfair gotcha game here of hiring some expert to then hold a deputy to a Herculean standard that the deputy had never heard of or been trained on. The plaintiff here only seeks to hold the deputy to the standard that he knew, he was trained on, and he violated. We're just trying to hold the sheriff's department to their own standard, and the expert verified that the standard was a good standard because it dealt with getting the lights off, the siren off, and being out of view of the fleeing vehicle. The Haynes factors, that's why I say of the Haynes factors, the applicable police regulations, that's the factor that I think has the greatest weight here, because the other factors in Haynes were considered by experts inside the sheriff's department when they decide what they want their policies and procedures to be. And the policies and procedures are about stopping this encouragement of the fleeing vehicle to do an extreme speed to try to get away from justice.
Thank you. Gentlemen, I want to thank you both for your presentation. It has been very well received, and you have done a great job, both of you. Your case now has been submitted to this court for resolution,